10. Let me let us decide along with that this batch of cases.
Now the
Pictures eligibility test. Now the judgment.
Supreme Court
Yes,
has
Supreme
Justice
Court
Doctor has
Supreme
I think he has already delivered a judgment.
Justice
It's mandatory now.
Justice Deepan Karda.
That is what a Justice Doctor I said.
Yes. But the read petition number 10430
What remains that on the basis
because
it is mandatory. One has to.
remains only the petitioner is governed under the old act. That is the he was
That was also argued before Justice
but
Doctor.
only I have to
Timeline was given. I think 2 years they have to qualify.
The law is
within 2 years.
Law is prospective in nature. There should be a lordship decide along with this batch of cases 2010-2020.
No, sir. There are two aspects because if I correctly remember,
Yes.
if my memory does not betray me. I think this was also argued that what would happen to a already in-service teachers who did not qualify. And I think the timeline was given.
But because only I have to
Why you are afraid, sir? 5 years time is
during
given.
the pending
is the
and during the pendency of this case, this judgment has come out.
That's
Now, because we have only your person to decide whether that is the law, that is the which govern.
I am telling you, I appreciate it. When you say that the law should always apply prospectively.
Yes, prospective.
Unless it is intended to apply.
Yes.
Prospective precedence and a retrospective precedence, we are conscious. But if the point has been decided by the apex court in a judgment, which concerns the point directly or indirectly, then in that event, that judgment has to be respected. It is because in the Supreme Court also, the plea was taken that what would happen to our teachers who have already been appointed and they are rendering services for such a long period of time. The Supreme Court says that no matter they do not have, we are giving them a timeline within which they will qualify this TEC. Then in that event, prospectivity and the prospectivity is gone, is blurred.
But here, there's some that is that is the predicaments. There is the has not been that is the appreciated by the Honorable Supreme Court because some persons in a old age at 25 years of serving may be put into the medical.
No, it's not a
because he or she is not able to qualify in the eligibility test. Then he will be terminated from the service.
No,
this should be decided.
TET, they have. This is not a question. They have to qualify the TET. They have to take the examination.
Examination. Yes.
That's all.
Yes.
Nothing more than that.
The examination means they have to qualify. This is a TET.
Correct.
Qualify because if he is put into the medical.
Can we go beyond the Supreme Court judgment? Because by virtue of Article 141, we are bound by that judgment.
Will decide in the batch of cases along with this. 28.
Please bring that judgment or give it that judgment.
I have also bring the judgment also. My lord. It's everything. And the WPC number 10430/2024.
Let it be added. When that matter is this
28.
So along with that.
10430/2024 read petition on 28. They also decide them.
Please. And bring that judgment of Justice Doctor.
Judgment. I have also.
Please. Yes, give it a. You keep it slow. I think I wanted a. 214 and 15
Yes.
are very
Yes,
clear.
very
When we
clear, very
go into the retrospective operation of it, we can't go into the
Mr. Rafa,
retrospective.
have you seen paragraph 214
14 and
215?
Answer.
That clinches your argument. Nothing remains. So can we reopen?
Can we
open this?
decide a retrospective operation? We can't.
Your Lordship will not only, your Lordship will say something because the petitioners have been working since
Correct.
there is a long 25 years back,
True.
and now they have become old, my lord, and now they are put into the hospital, and they are not unable to give the TET examination.
True.
And unless until they qualify the TET examination, they will be terminated. They will be ousted from the service.
Correct.
That has not been decided by.
That is what is decided, sir.
Yes, your Lordship.
This Roman 8 is order on applicability of the TET to in-service teachers.
Yes.
That is your case.
Yes.
214 says, per the details discussion above and resting on the same, we hold that provision of RTE Act have to be complied with
Yes.
by all schools as defined in section 2N of the RTE Act, except the schools established and administered by the minority, whether religious or linguistic, till such time the reference is decided, because the status of 29.2 of the Article 29.2 was there. And subject to the answers to the question formulated in section 7. Logically, it would follow that, now I am reading very slowly, in-service teachers, within bracket, irrespective of length of their service. Now, when you are talking about 25 years, 30 years, bracket closed, would also be required to qualify TET to continue in service.
Yes.
Then, however, we are mindful of the ground's realities as well as the practical challenges. There are in-service teachers who are recruited much prior to the advent of RTE Act and who might have put in more than 2 or even 3 decades of service. They have been imparting education to their students to the best of their ability without any serious complaint. It is not that the students who have been imparted education by a non-TET qualified teachers have not shown in life. To dislodge such teachers from service on the ground that they have not qualified the TET would seem to be a bit harsh, which you are arguing. Although we are alive to the settled legal position that the operation of the statute can never be seen as an evil. Bearing in mind this predicament, we invoke our powers under Article 142 of the Constitution of India and direct that those teachers who have less than 5 years of service left,
Yes.
as on date, may continue in service till they attain the age of superannuation without qualifying TET. However, we make it clear that if any such teacher having less than 5 years service left aspire for promotion, he will not be considered eligible without having qualified the TET. Then, insofar as in-service teachers recruited prior to amendment of RTE Act and having more than 5 years to retire on superannuation are concerned, they shall undergo an obligation to qualify the TET within 2 years from the date in order to continue in service. If any of such teachers fail to qualify TET within the time that we have allowed, they shall have to quit service. They may be compulsorily retired and paid whatever the terminal benefits they are entitled to. We add a rider that to qualify for terminal benefit, such teachers must have put in qualified period of service in accordance with the rules if any teacher has not put in qualifying service and there is some deficiency, his or her case may be considered by the appropriate government upon representation being made by him. Now, after that, can we go into that retrospective or prospective?
Last part, this is a prior to amendment of this Act.
Sir, this is what it says. It says that a teacher, the very sum and substance of the entire judgment is there. First thing, RTE Act mandates TET as an eligibility qualification, which is mandatory.
Yes, yes. My lord.
Have.
After commencement of this Act.
I am coming.
Yes, yes.
Don't worry.
No.
I am going one by one.
Yes.
First thing is that RTE Act mandates the qualification to become a teacher, the eligibility test, that is a teacher eligibility test. First criteria. Second is no appointment can be made after RTE Act came into force in respect of or to the post of a teacher unless the person has qualified TET test. Correct. Now, third, that in-service teachers who were appointed prior to coming in force of RTE Act have to qualify TET test first.
Yes.
Exception is that only those teachers who are going to retire within a period of 5 years from the date of this order, then in that event they need not have to.
Here it is a
Please.
My lord.
They need not have to qualify TET test, and they will continue in service and retire. Again, if they claim any promotion, then in that event they have to qualify TET. Otherwise, they will not claim promotion. Thirdly, any teacher having no TET qualification, having more than 5 years of service, then in that event they have to qualify TET within 2 years from the date of the order.
My lord, is it 5 years?
If they do not,
Yes.
the consequence is also provided, sir.
5 years.
If they do not qualify, then they should be removed from service,
Yes.
either by way of compulsory retirement, by giving them a terminal benefits, and then also giving them a pension, provided they fulfill that particular qualifying service period. In the event they are not, then also the right is given. They can approach the appropriate government and can make the prayer. The appropriate government was given the full discretion to decide those what to do and what not to do. This is how the crux of the matter. Now you tell me what is the point.
I bow down the judgment of the Honorable Supreme Court. But Supreme Court, there is a
So we also.
Here, Supreme Court has also discriminated. Why 5 years?
Can we say?
Why 5 years?
I am asking you, sir, can we say
That's
as a high court, because of Article 141, can we say anything?
Yes, your lordship will decide in this line.
No, can we say?
It's on that.
If the Supreme Court has said, can we say that this is wrong? We can't say that.
That's
We are bound by Article 141.
Again, we
sir.
have to, so they are also.
You go there. What can be done? We are deciding it here on the basis of this judgment.
My lord, only 2810.
No.
Your lordship may decide only 2 p.m.
What for?
2 p.m. my lord. Everything with response. decide everything all
We
very
are dictating it and it will be dated on 28th.
2010.
We are dictating it.
Online when
Yes.
I wrote it. Only may do pay me.
Not remains,
Lord, I know that, my lord, because during the pendency of this writ petition, during the pendency,
open and shut case.
and
That
during the
judgment,
pendency
so
of
far
this
as that
case,
judgment is concerned, there is no dispute, my lord.
Ah.
What is the problem here? That the service of the petitioner is governed by the elementary cadre rule of the state. The elementary cadre rule was amended in 2019,
97.
granting exemption of TET to the teachers who were appointed prior to 11/2/2011. Now, the virus of that statute is the subject matter of challenge in the batch of writ petitions which your lordship have posted to 28. So that particular cadre rule, their service is now governed by the cadre rule, vis-a-vis the statutory provision as provided under the RTE
No,
Act,
because RTE Act is a central legislation.
central legislation. So that repugnancy has to be decided by
So
the.
that any subordinate rules or subordinate legislation which offends the very core, I think the ethos of the parent act.
Yeah, yeah.
Can it go? Can it continue? Not.
And the central legislation was also amended in 2017, granting the teachers liberty to acquire their qualification
That was
within
a
a period of
5 years.
5 years. That was. But 2019, the elementary cadre rule amended, granting exemption. So that is why the virus is under challenge.
Sit with your students. Pass out the class 10 examination or class 12 exam.
Yeah.
Sit with them.
But
Teaching them and then say,
because there is something we have to approach, because there is some discrimination and some predicaments. That's why we have pointed what I have allowed.
I have not come across any judgment of law.
Yes.
That a judgment of the
Yes, yes,
court
I-
can be said to be a discriminatory in nature.
Yes, ma'am. Yes, ma'am.
Virus has not been challenged. Only application of the central legislation is the subject matter here. But he has endorsed that cadre rule. He has
Virus has been challenged. That is
After perusing the